Good morning. Our first speaker is a representative of the government of Norway, and it will be very interesting to hear what Mr. Roger Schjerva, the State Secretary at the Ministry of Finance, has to tell us about this. From what I can tell from my paper, the talk is titled Norway's Positions, Interests and Values. So, Mr. Schjerva, please take the floor.
Thank you for a nice presentation, Runeberg. Ladies and gentlemen, good morning. Nice to see you. What Runeberg didn't tell you is that my job is to disappoint people. My job in the government is to say no till the other ministries, until the finance minister says yes. And my job is to step in and give his speeches when the Prime Minister or the Parliament calls for him, and give his speeches. And you know, Finance Minister Johnson is the most popular finance minister in Norway ever. So, and I'm just me, so I am walking disappointment. But I can assure you that I'm just not stepping in. This is an issue that I'm very personally engaged in, and it is also a subject that is one of my main responsibilities in the ministry. So we are here because we want change. We want to stop tax revenues from being hidden from governments in developing countries, and we want to stop corruption, corrupting society. We want to stop international tax crimes for a more just and fair world. And we all here, I think, share this vision. And I would like to congratulate the organizers of this conference for delivering an impressive arrangement. And I very much appreciate the excellent initiative of the Publish What You Pay and the Norwegian School of Economics to organize this conference. The fight against international tax crimes is high on the agenda of this my government, and the extent of information sharing and transparency is now at a level that was unimaginable just a few years ago. The Nordic countries have taken the lead in this development, and we have this position because we have, through 1972 Nordic Convention, had 40 years of experience of close cooperation, working together against tax crime. We know how important this is, and we are bringing with us this knowledge when we work with the rest of the world. The change we have seen is partly caused by technological development. Monitoring cash flows got considerably more challenging the day money could be transferred by the click of a key instead of money in a bag. Against this, we see a change of culture. The Nordic countries have pushed a culture where secrecy is not okay, and it's a long way to go. But there are good reasons to be optimistic. So where are we now, and where are we heading? Today I will look deeper into some different fields. First, I'll start with the status of country-by-country reporting, a major breakthrough when it comes to financial reporting. I will then make a few remarks of the Financial Action Task Force, where we now have a leader from Norway. And I will also speak about the work of the OECD against harmful tax practices and the Global Forum on Transparency and Exchange of Information in Tax Matters. And at the end, some remarks of the professional secrecy of lawyers. So, I would like to start by stating some basic information about country-by-country reporting, CBCR. CBCR is a different concept from regular financial reporting, as it presents information for every country that a company or their controlled subsidiaries operates in, rather than in a single set of information at a global level. As of today, there are no regulations in Norway or in the EU which impose companies to report operational information on a country level. Nor are there any other requirements to enhance transparency of payments made to governments in countries where the companies conduct their business. As a consequence, it is today virtually impossible to deduce from the companies consolidated financial statements on how much of the company's total revenue and expenses that relate to their business in each country they operate. Reporting requirements showing what a company pays to host governments, like taxes, royalties, and bonuses, is likely to show a company's financial impact in host countries. And it is my opinion that such a transparent approach will encourage more sustainable businesses, as it highlights payments flow from developing countries. The challenges related to payment flows from developing countries have, among other aspects, been further described in the so-called Tax Havens report from 2009. The report was taken by the initiative of the Ministry of Development and headed by the Professor Schjerva, which I think was one of the first speakers yesterday, sitting here. And this report points out CBCR as an important instrument to promote greater transparency in payment flows related to operations in developing countries rich in natural resources. The government followed up the report, first through a working group and then in the government's action plan against economic crime. The action plan calls for further work with implementing national CBCR requirements, either as a part of the work which is being done in the EU or independently. The Norwegian government is of the opinion that a set of international CBCR regulations would be the best solutions, but is at the same time of the opinion that absence of such international regulations should not prevent the Norwegian authorities from implementing CBCR requirements nationally. Last October, the European Commission presented a proposal for a new directive on the annual financial statements, which included CBCR requirements. The Commission's proposal is still under consideration by the Council and European Parliament, and the provisions on CBCR requirements are challenging to agree on. I have been informed that a plenary decision on the proposal is planned for January 2013. The Commission's proposal for CBCR regulation is imposed for large companies and all listed companies in extractive industries and the logging industry. Companies subject to CBCR regulation must on an annual basis report on payments made to governments in countries where such operations are conducted, including information on payments related to specific projects. The purpose of the CBCR regulation is to enhance transparency of payments to governments, which will be helpful in the combat against corruption and also in promoting good governance. The European Commission considers the proposal for CBCR regulation to be comparable with the CBCR regulation in the Cardin-Lugar Amendment contained in US Dodd-Frank Act. And the Cardin-Lugar Amendment has been hailed as one of the main anti-corruption measures in the US law in recent times. The Norwegian government welcomes and generally supports the European and American initiatives on introducing reporting requirements on a country-by-country basis. The proposal is in line with the Norwegian government's work related to increased transparency in international payment flows. And I also find the proposal to be in line with the government's efforts to enter into tax information agreements with so-called tax havens with the purpose to combat tax evasion. In the view of the Norwegian government, CBCR regulation will have the greatest impact, of course, if there is an international consensus on implementing such regulations. EU legislation will have a direct impact on the Norwegian legislation through the EEA agreement, and is therefore important for the Norwegian government that EU rules are as good and robust as possible. So the government sent the Commission's proposals, therefore, on a public consultation in December 2011, with a deadline for submitting comments within the end of January this year. In a sense, the bodies entitled to comment were positive to the introduction of CBCR, but divided in the views on the specific content of such provisions, and of course also when such provisions should, when such CBCR should come into place. In July this year, the government decided how Norway should continue with its effort to introduce CBCR and what positions Norway should pass over to the EU in the development of the CBCR regulations there. The government concluded, among other things, that it is important to have a good and robust EU legislation as possible, but at the same time one should not impose disproportional additional administrative burdens on companies. CBCR requirements should help visualize the extraction of natural resources, and it should be clarified that one purpose of the CBCR regulation should be to prevent tax evasion and to help identify tax revenues resulting from the extraction of natural resources. And we also concluded that an evaluation of the CBCR regulation should be held after 3 years and include an assessment on if the CBCR requirements should be extended to other sectors. And finally, it was decided that the Norwegian government would work to enact requirements for CBCR in the EEA areas as quickly as possible, and that Norway aims to enact rules from 1st January 2014, even if the entry into force should occur at a later point of time in the EU. The Norwegian position were passed to the Commission, Council, and various members of the European Parliament in July this year, and we are now awaiting the final CBCR regulations in the EU. We also have a process in the Norwegian Ministry of Finance, where the aim is to put into force Norwegian CBCR requirements by 1st January 2014, regardless of what happens in the EU. So, country-by-country reporting is an important step towards sustainable businesses. What I mean with sustainable businesses, I mean a business that is able to and open in how they pay rents to the owners, salaries to the workers, and tax to the society. Norway is prepared to take a lead position, and if we manage to get this into international regulations, it will be a leap in the fight against tax crimes. Now I would like to change the subject and direct your attention to the work of the Financial Action Task Force. I love the sound of that name. It sounds like something from Hollywood. But Financial Action Task Force, FATF, is utterly real and important. They are both pushing new standards, where Norway have been actively involved in the revision of the new and improved standards, and executing investigations and reporting to local authorities. So who are they? FATF is an intergovernmental body which was established by the G7 summit in 1989. And the objectives of FATF are to set standards and to promote the implementation of measures for combating money laundering and the financing of terrorism and proliferation of weapons of mass destruction. In April this year, the mandate of FATF was renewed by ministers and other representatives of member jurisdictions for another 8 years. The FATF currently comprises 34 jurisdictions and 2 regional organizations. This is the European Commission and the Gulf Cooperation Council. Approximately 150 additional jurisdictions have committed themselves to implement the FATF standards through memberships in various associated organizations, the so-called FCRSCB, Financial Action Task Force regional style bodies. Members of the FATF and the FSRBs also commit to undergo mutual evaluations. In July this year, Bjørn Skogstad Åmo, which is a special advisor in the Norwegian Ministry of Finance, undertook the presidency of the FATF for a one-year period. He was vice president last year. And he's a man that has my greatest respect, because he's the only one that has served for a longer term as a state secretary in the Ministry of Finance in Norway than me. In February this year, FATF adopted 40 new and revised recommendations. And in my opinion, the new recommendations represent enhanced measures to fight secrecy, economic crimes in general, and tax crimes in particular. And let me mention the 2 new recommendations which we, from the Ministry of Finance, look upon as probably the most important ones. First and foremost, tax crimes are now included in the recommendations list of designated predicate offenses for money laundering. This means that member jurisdictions commit to criminalize money laundering from tax crimes. And furthermore, banks, financial institutions, and other subjects to the recommendations are obliged to report to their national FIU, Financial Investigation Unit, and when they suspect that their clients are laundering the proceeds of tax crimes. This enables the FIU to share important information with national enforcement authorities and with other FIUs in other countries. In Norway, there are also good mechanisms in place for the dissemination of information and analysis from the FIU to the tax authorities. The new recommendation do not provide for a definition of tax crimes, nor do they provide for any further clarifications as to exactly what types of tax offenses member jurisdictions are obliged to define as a predicate offense for money laundering. And this absence of stricter guidelines leaves room for a relative flexible approach as regards the implementation of the new standards into national law. And this flexibility is a challenge from a Norwegian point of view, but there's no doubt that the inclusion of tax crimes in itself constitutes an important step in the right direction. Norway, as a member of FATF, has initiated a mapping exercise for all FATF countries regarding tax crimes as a predicate offense. And hopefully the experiences from jurisdictions where the laundering of proceeds of tax crimes are already criminalized, like in Norway, can be of benefit to other jurisdictions. Secondly, when it comes to who is the real owners of business. Secrecy and lack of information about the ownership of legal persons and arrangements make such instruments vulnerable to the misuse of criminals. And the revised recommendation comprise enhanced requirements and measures to improve transparency of beneficial ownership and control of companies, trusts, and other legal persons and arrangements. Certain basic information is required to be registered in a public company registry, and information on shareholders and members must be maintained within the country of registration. The new recommendations also specify what steps financial institutions and other reporting entities are required to take in order to detect the ultimate beneficial owner of a client account. Furthermore, trustees and others operating on behalf of legal arrangements similar to trust shall be required to disclose their status to financial institutions and other reporting entities. Trustees and others with similar functions are to be required to obtain and hold adequate, accurate, and current beneficial information. Let me then turn to the OECD's work on harmful tax practices and on the Global Forum on Transparency and Exchange of Information for Tax Purposes. Working together in international arenas like the OECD is vital if we are to succeed. In the paper describing the purpose of this conference, you mention milestone achievements in transparency reform in the US and the EU, and the need for collaboration across borders in these matters. And transparency and access to information are indeed keywords when we discuss how to deal with financial secrecy, and in particular to combat tax evasion. These achievements are, however, not limited to the US and EU, but are now global. And this is a result of wide international collaboration, and Norway has played an active role. Let me address these developments with a few words. Norway chaired the OECD group that drafted the report Fiscal Degradation, that declared action against secrecy and harmful tax competition. The OECD 1998 harmful tax competition project to counteract these developments between member states also put the focus on the tax havens. Tax havens were told to accept transparency and effective exchange of information for tax purposes, including the lifting of bank secrecy, or to face defensive measures from other countries. After a rather reluctant start around 2000, a number of tax havens made commitments to accept tax information agreements which would lift bank secrecy in OECD countries, but developments to conclude tax information agreements were slow. In the beginning of 2009, the G20 declared the end of bank secrecy on a global scale. And the declaration didn't change the world overnight, but it was important. It led to the lifting of bank secrecy in OECD countries like Switzerland and Luxembourg towards their tax treaty partners, and general action against jurisdictions that offered hiding places for tax evaders. But on an initiative from the finance ministers in the Nordic countries, already in 2006, we started up the Nordic Tax Havens Project. And the project is to jointly negotiate tax information exchange agreements. And after the G20 initiative, we experienced a boost in the willingness to conclude tax information agreements. Today, such agreements, we have such agreements with 39 jurisdictions that have been signed, and negotiation to conclude with the remaining 5 on the OECD list of closed financial centers are now at a final stage. If we succeed, the Nordic countries will be the first to achieve a full network of tax information exchange agreements, and there will no longer be places where Norwegian tax evaders can safely hide money. The Global Forum on Transparency and Exchange of Information for Tax Purposes was established later in 2009, much as a consequence of the G20 statement. And the GF, the Global Forum on Transparency and Exchange of Information for Tax Purposes, or GF, And the GF standard is to provide information on request, including from banks and financial institutions, and on ownership of letterbox companies, trust, etc., and to oblige members to conclude tax information agreements. All GF members are subject to a thorough peer review process to ensure that the standard is observed. The GF consists of all OECD members and all financial centers, but has now 116 members and is steadily growing. In particular with developing countries joining in. Let me also mention the OECD and the Council of Europe multilateral agreement on administrative assistance in tax matters, which is now open to all countries. All the OECD members, all the G20 countries, and a number of financial centers have signed or declared to sign, and a number of developing countries have declared an interest to join. This multilateral agreement also includes possibility for automatic exchange and assistance in the recovery of taxes. And this may be the tool developing countries need to counteract illicit capital flows instead of having to seek resource-demanding tax information agreements. Illicit capital flows from developing countries can also take the form of disloyal or even fraudulent transfer pricing practices. So access to relevant market price information from G20 and OECD countries can be crucial to be able to counteract such practices, and can be achieved through the multilateral OECD and Council of Europe agreement. Tax information agreements are a strong and important tool, new tool. We see that these arrangements work and bring in considerable sums in evaded tax in the Nordic countries. But it has weaknesses. Information on request is resource demanding, but it's a start. And to many countries, it represents a fundamental change in policy. Automatic exchange of information should be the goal, and we strongly support it. And there are now some good news, because we are watching developments in the EU on the savings directive, and in the US on the FATCA arrangements that may promote automatic exchange as a common practice, as the Nordic countries have had in place actually since 1972. And as mentioned, the multilateral agreement may be the necessary tool. Just a few years ago, nobody believed bank secrecy would be lifted at all in some countries. So the transparency and access to bank information we have achieved is a result of hard work, patience, and effective collaboration across borders, and this we will continue. I have spoken of access to information, which is what transparency is all about. Another important subject related to the theme of this conference is lawyers' duty of confidentiality. Merete Smith, Secretary General of the Norwegian Bar Association, will go further into this topic later today, but I will use this opportunity to emphasize a few aspects of this subject. And of course, you must bear in mind that I will see it mainly from the Norwegian tax authorities' point of view. The Norwegian tax system is based on the obligation for the taxpayer to each year give all necessary information needed to determine correct tax. The tax authorities also obtain a lot of information from different third parties, such as, for example, banks. In addition to the taxpayers and third parties' duty to on their own give information to the tax authorities, the tax authorities may use their control provisions, which impose on taxpayers and third parties a duty to give further information on request. Lawyers' duty of confidentiality is very often referred to as a strong duty of confidentiality, and thereby has a stronger protection than other duties of confidentiality. In Norway, as in most countries, it is set down in the penal code that breaches of lawyers' duty of confidentiality is punishable. And in addition to the prohibition in the penal code, there are rules in both the criminal procedural code and the civil procedural code that prohibit the court to take evidence about something that falls under a lawyer's duty of confidentiality. However, in Norway, there is no legal provision that expresses directly the content of lawyers' duty of confidentiality. Also, Article 8 of the European Convention of Human Rights provides a general protection for correspondence with a lawyer, among others. However, this does not mean that no exception from the duty of confidentiality can be made. Intervention in the protection given in Article 8 is possible if it, for example, is valued as necessary in a democratic society in order to prevent crime. Such an intervention then must be established by law, and there must be proportionality between the burden of the intervention and the purpose of the intervention. An exception in lawyers' duty of confidentiality has, for example, been adopted in the Norwegian money laundering legislation, and when certain conditions are fulfilled, lawyers have a duty to report to the financial intelligence unit at the police. To be able to determine correct taxes, it is essential for the tax authorities to receive accurate information about transactions and money transfers, including information about to and from whom the transaction has gone. The need for information is the same if a lawyer has been involved in the transactions. Earlier, the tax authorities had few problems receiving this kind of information in Norway. Also, if the relevant information was to be found in correspondence with a lawyer. But this has now changed. The tax authorities' legal right to ask a taxpayer for information that is in his correspondence with a lawyer has in general been challenged. Because in December 2010, the Norwegian High Court came with a decision where it was determined that money transfers that take place as an integrated part of lawyers' natural practice is protected by the duty of confidentiality, including the name of the client. The decision has influenced the understanding of the tax authorities' right to ask for information existing in correspondence to or from the taxpayer's lawyer. Therefore, the legal situation now is that the tax authorities cannot require information from correspondence with a lawyer if the information falls under the duty of confidentiality. And this means, among other things, that the tax authorities do not have legal right to ask for information about money transfers that take place through a lawyer's client account. And this again implies that it is possible for a disloyal taxpayer to keep information on capital and income away from the tax authorities. If the tax authorities turn to the banks to get information from them about from who and to whom a money transfer has gone, this will not be in the bank's position. This because the money transfer has been done in the name of the lawyer. So the tax authorities are in a situation where they have no access to this kind of information. And this is not an acceptable legal situation. And I will not accept that all our effort to combat secrecy for the wealthy in tax havens will be undermined by lawyer offices in Oslo or in Bergen. Because it's difficult to see the reasoning why lawyers' duty of confidentiality should be used to protect access for the tax authorities to this kind of information. Lawyers' duty of confidentiality, protecting access for authorities to relevant information, is not only a problem in Norway. From the agenda you will be discussing this very important problem from, I see that you will be discussing this very important problem from different angles today, and I look forward to hear about the results of these discussions. But what does the government do about this problem in Norway? In the tax area, we need quick action. So the Ministry of Finance is now working with a proposal for changing the Tax Assessment Act. Our aim is to send out before Christmas a proposal that imposes on lawyers a duty to give information about money transfers through their client accounts this year. But as I mentioned, not only the tax authorities are experiencing problems connected to information not being available for them because of lawyers' duty of confidentiality. The decision from the High Court that I just referred to was related to the police and prosecuting authorities' right to receive information about transactions through a lawyer's client account in an ongoing criminal investigation. So the Ministry of Justice is working to appoint a legal committee that will work out a proposal for a new legal framework for lawyers and others offering legal assistance. This committee will, among other things, examine and give an account on the legal situation regarding lawyers' duty of confidentiality. The committee will also be given the task to propose new legislation related to lawyers' duty of confidentiality. In this regard, one important task will be to define which parts of a lawyer's task that should fall under the lawyer's legal practice, and then again be found by professional duty of confidentiality. Before I wrap up, I would also like to give a short mention of another important work being carried out by the OECD to achieve our goal to fight financial crime and its harmful effects on society. We of course have to work on different areas at the same time. And the task force on tax crimes and other crimes under the OECD Fiscal Committee are working with topics related to tax authorities' possibilities to discover other financial crime than tax crime, for example, money laundering and corruption. They cooperate with the FATF and the OECD Working Group on Corruption. For 2 years now, they have been working with a special project to promote a whole-of-government approach to tackling financial crimes and illicit flows. In 2011, Norway hosted the launching conference of this project called the Oslo Dialogue. It's a long time since Israel and Palestinian negotiations. This year at the Rome conference, a document describing effective interagency cooperation in fighting tax crime and other financial crimes, we launched the so-called Rome Report. And the report describes organizational models for agencies fighting tax crimes and other financial crime. Models for sharing information, models for enhanced cooperation, and also recommendations. One of these recommendations is that countries review their models for enhanced cooperation described in the report. Joining forces in the fight against financial crime and illicit capital flows is essential, and I look forward to follow the work set out in this project. And I hope this report will inspire countries to analyze and develop new methods and systems of cooperation in the future. I'm getting to the end of my time here at the podium. As I said at the beginning, we share a vision of a more just world where tax crimes are effectively prevented and stopped. One of the major tasks ahead is country-by-country reporting. Norway is prepared to take the lead. CBCR can prevent tax evasion and identify tax revenues to prevent exploitation, or in other words, robbery, of a country's wealth in natural resources. If we manage to get this into international regulations, it will be a leap in the fight against tax crimes. Our men and women in the field is the Financial Action Task Force, and in OECD and the Global Forum. It's hard work dealing with countries and interests, often with another point of departure than us, but the work has to be done. It's a dirty job, but someone has to do it. When it comes to lawyers and secrecy, we are now setting up a new legal framework because the current situation is not acceptable. Joining forces in the fight against financial crime is essential. International standards are necessary. It's a long and winding road, but we will get there. I would also mention that Publish What You Pay and other non-governmental organizations are playing a very important role, and they inspire, share knowledge, and is making the ground for new political actions. And so you are all needed in this fight. And together we can make a change for the better. Thank you for your attention.